All right, let's jump right into this explainer. We're looking at a fascinating true crime story today that, honestly, accidentally triggered a massive constitutional showdown over the absolute limits of judicial power. We so often think of constitutional law as something that happens in these quiet, sterile courtrooms, debated by scholars over abstract concepts. But sometimes, the most profound legal principles are forged in the most unexpected of places. Today we're diving into a case that started with a police raid and literally ended up forcing South Africa's highest court to answer a fundamental question about how our government actually works. It all starts with two Santon businesses, the Ranch and the Titty Twister, whose legal freezing led to a bizarre, escalating crisis. These businesses operated out of a property in Rivonia. The Ranch was an upscale brothel, and the Titty Twister put on striptease shows. The owner, Andrew Phillips, was running a highly lucrative operation right up until the authorities decided to crack down. And what happened next wasn't just a standard criminal trial. It was the start of an epic legal tug-of-war over the property itself, leading to unpaid municipal bills, rotting buildings, and a full-blown constitutional crisis. So in February 2000, things escalated fast. Law enforcement officers raided the properties. Almost immediately, the National Director of Public Prosecutions stepped in and had the assets preserved. Then, in December of that same year, the High Court slapped a massive restraint order on the owner, Mr. Phillips. And we're not just talking about a minor infraction here. Phillips faced a whole slew of serious charges under the Sexual Offenses Act and the Aliens Control Act, ranging from keeping a brothel to employing and harboring undocumented immigrants. The state wanted to make absolutely sure that if he was convicted, they could confiscate the proceeds of these alleged crimes. So they froze everything, the whole shebang. Which brings us to part one, the raid and the frozen assets. See, freezing a bank account is one thing, but freezing an entire physical, operating business complex, that is a completely different nightmare. To manage this frozen empire, the court appointed a legal figure known as a curator bonus. In this specific case, a guy named Mr. Van den Heever from Deloitte & Touche was given the job. His responsibility was simply to assume control over the property, take care of it, and administer it while the lengthy criminal trial played out. I mean, it sounds totally straightforward on paper, right? The state seizes a property, hands the keys to an accountant, and basically says, hey, keep this safe until the trial's over. But, as we'll see in part two, it was a curator's impossible task. Because of the nature of the alleged crimes, the curator understandably shut down the brothel and the strip club. That meant zero cash flow. Suddenly, there is absolutely no income being generated by the properties. Meanwhile, the municipal bills for water, electricity, and property rates are aggressively piling up. And without any maintenance, the physical properties started to rapidly deteriorate. Now here's the truly wild part. The curator actually tried to lease out the properties to legitimate tenants just to generate the funds to save the buildings. But Phillips, the owner, went to court and got an urgent interdict legally blocking the curator from leasing them out. And then, get this, Phillips turned right around and tried to have the curator held in contempt of court for failing to pay the property bills. It was a completely paralyzed situation, a total catch-22. So what happens next? Let's look at part three, the High Court's loophole. Phillips watched his properties crumbling, weaponized the very situation he helped create, and went straight to the High Court. He demanded the restraint order be entirely rescinded, arguing the curator's task was physically impossible. But he hit a massive legal wall. The Prevention of Organized Crime Act, specifically Section 26, subsection 10. The lawmakers who wrote this act were smart. They knew criminals would try every trick in the book to unfreeze their assets, so Parliament wrote very strict, very narrow rules for when a restraint order could be lifted. According to the act, you can only unfreeze assets in very specific cases of extreme personal hardship, like if the order literally deprives you of your reasonable living expenses. Phillips was a wealthy businessman, so he didn't exactly meet this criteria. His complaint was about the decaying value of his property, not that he couldn't afford to buy groceries. However, the High Court judge looked at this absolute mess, the rotting buildings, the mounting bills, the total gridlock, and decided to act kind of like a referee inventing a new rule just to keep the game moving. The judge used a legal concept called inherent jurisdiction. Essentially, the High Court decided that because it's a superior court, it has an inherent common law power to fix its own broken orders. The judge ruled that the strict rules in the act didn't actually strip away the court's overarching power to just cancel the whole thing in the interest of justice. And just like that, the restraint order was completely rescinded. But the state wasn't having it. Here is part four. The Supreme Court reverses. The National Director of Public Prosecutions refused to accept this ruling and immediately appealed to the Supreme Court of Appeal. The state argued that you can't just ignore a law passed by Parliament simply because a situation gets complicated. The High Court felt it could fix a broken, real-world situation using inherent common law power, but the Supreme Court of Appeal drew a hard line. They basically said, no way, a judge cannot simply rewrite an act of Parliament. The SCA pointed out that the restraint order wasn't a common law invention. It was created by a specific statute. Therefore, the power to undo it must also come from that specific statute. If Parliament didn't write an out for this exact problem, the courts couldn't just invent one out of thin air. So the SCA reversed the High Court's decision, slapping the freeze right back into place. And this really sets up the ultimate cliffhanger for us. What actually happens when a court's desire to fix a practical, real-world mess collides with the strict letter of the law? Can a judge ignore a statute just because it's creating an administrative disaster? I mean, this goes straight to the heart of the separation of powers. Lawmakers write the laws, and judges interpret them. If judges start ignoring laws they find inconvenient, where does it all end? Which leads us to the grand finale, Part 5, the Constitutional Court decides. Refusing to back down, Phillips took his case all the way to the highest court in the land, the Constitutional Court, and Judge Squiea took a very firm stance. Courts cannot just invent loopholes when Parliament has explicitly written the rules. The judgment made it crystal clear that you cannot simply sidestep an act of Parliament. Even if the situation on the ground is a total, unmitigated disaster, a judge's inherent power is absolutely not a blank check to override the democratic will of the legislature. Now, Phillips had tried to argue that Section 173 of the Constitution gave the High Court the ultimate power to do whatever it needed to do to regulate its own processes. But the Constitutional Court clarified what Section 173 actually means. Yes, courts have inherent power. But here's the crucial point to remember. This power is designed to fill a legislative vacuum. If there is absolutely zero law in the books dealing with a specific procedural issue, well, a court can use its inherent power to bridge that gap so justice can be served. It's a tool of last resort. It is definitively not a magic wand to escape inconvenient statutory procedures that Parliament has already intentionally put in place. But the Constitutional Court still had to deal with the rotting buildings and the piling bills, right? They couldn't just leave an impossible situation unresolved. So they brilliantly solved the mess using the existing rulebook. Step 1, keep the restraint order in place. Respect the act. Step 2, look closely at the wording of the order. It said no dealing with the property. The court said, okay, let's read that narrowly. No dealing means you can't sell it or you can't take out a mortgage on it. It doesn't mean you can't use it. Step 3, use Section 28 of the Act, which explicitly allows a court to alter the powers of a curator. They just needed to amend the curator's specific powers so he could legally lease the property out to legitimate businesses, generate an income, and pay those municipal bills. Problem solved. They fixed the mess without handing the criminal assets back to the defendant and without breaking the law. So, this whole saga leaves us with a fascinating question to ponder. This story, starting at a raided strip club in Rivonia, ultimately defined the delicate balance of power between the people who write the laws and the judges who enforce them. The Constitutional Court showed us that true judicial brilliance isn't about ignoring the rules when things get tough. It's about finding the solution within the strict framework of the law. But it begs the question, if a law creates an impossible situation, should judges have the power to rewrite the rules, or must we endure the mess and wait for lawmakers to fix it? Let that sit with you for a bit. Thanks for joining this explainer, and keep questioning the structures around you.